happy personally to be here representing IRCT and also representing our members. So just to start, I would like to say a few words about the IRCT. It's the International Rehabilitation Council for Torture Victims, and it's a network organization comprised of 176 members across 80 countries. So we work in partnership with centers of rehabilitation for torture victims. That means that we primarily work with centers where psychologists, doctors, social workers receive survivors to help them reintegrate society, restore their dignity, and we help them develop advocacy strategies. And so my precise position here at the UN is really to bridge the gap between the local organizations and the international human rights system at the UN. We are also part of the UATC consortium, the United Against Torture Consortium, with 5 other international NGOs. So together we really try to have the biggest impact possible on the fight against torture on different pillars. Would that be prevention, protection, accountability, and rehabilitation of torture victims, of course. In Lebanon, we work precisely with a committee, with CLDH and Restart Center Lebanon. And so with them, we prepared a joint stakeholder report for the UPR. And I'm really here to echo our most important preoccupations that arise from the report and try to, of course, do that in collaboration with our other panelists, really to have an overview picture of what is going on in Lebanon regarding human rights and the fight against torture. I would like precisely to highlight 3 main points. The first one is the insufficient criminalization of torture in domestic law. The second point is the absence of a functional and effective national preventive mechanism. And the third point is relating to the insufficient state services for the rehabilitation of torture victims. So under the first point regarding the lack of criminalization of torture in domestic law, maybe this has been mentioned before, but the anti-torture framework in Lebanon is comprised of Law 65, and this is the law that really defines the crime against torture and the adequate penalties. It's a law from 2017. And it really is an application of the UN Convention Against Torture, which was ratified by Lebanon in 2000. However, this law is not sufficiently applying the provisions of the United Nations Convention Against Torture, because it doesn't define precisely the crime as it's normally required by the Committee Against Torture. It doesn't provide sentences that are commensurate with the offenses, and the problem is that it risks not being deterrent enough for potential offenders. The other issue is that there are statute of limitations with this law, and this has been ruled several times by the Committee Against Torture as not complying with the Convention Against Torture. However, in Lebanon, Law 65 allows for statute of limitations ranging from 3 to 10 years, which impedes the investigation of torture cases. Especially when we are talking about torture victims, we must always be reminded that torture victims are people that suffers with severe trauma, PTSD, post-traumatic distress syndrome. So it can be difficult for them to lodge complaints and be involved in such a procedure. So it's even more important that the law does not provide any statute of limitation so that people can lodge complaints even after a period of time. Another important challenge for me that relates to the definition of torture is the fact that the military court, the permanent military court in Lebanon, still has jurisdiction for a wide range of crimes that can be deemed as acts of torture. And that really impedes fair trial rights and also just legal proceedings to really have those perpetrators found guilty. The issue is that the Permanent Military Court has jurisdiction over crimes against national security, but also over crimes that are relating to terrorism. But that can be interpreted, and that is in fact interpreted with a very broad perspective. So as a result, this structure raises several concerns on impartiality, on how judges form decision, because this court is comprised of 4 judges, and 3 of them are from military background. 1 of them is from civilian background, but even though the crime might be of civilian nature, they will still, the Permanent Military Court will still have jurisdiction over those facts. It also raises concerns over the defendant's right to a fair trial. My second point relates to the absence of a functioning National Preventive Mechanism. The National Preventive Mechanism, or NPM, as we usually call it, is the national body that is in charge of making sure that acts of torture do not happen within places of deprivation of liberty. They exist as a result of the ratification of the OPCAT, the Optional Protocol to the Convention Against Torture. Lebanon has ratified the OPCAT in 2008, so that means that it committed to establish a national preventive mechanism in Lebanon, which is a national body of experts that can go to places of deprivation of liberty to monitor and express recommendations on the applications of human rights and, most importantly, of the prevention of torture. It is designed not to be naming and shaming body, but really a body that works in complementarity with the authorities, but also with the victims, with the prisoners usually, and that can really provide for positive experience, positive recommendations to work towards a goal of prevention of torture. However, in Lebanon, the National Preventive Mechanism, which is the Committee for Prevention of Torture, is not functional. For a long period of time, the organizational decrees were not published. So the CPT in Lebanon has been established in 2008. However, the organizational decrees were only issued last month, actually in December or November 2025. So that means that for a long period of time, the experts on the board of the CPT did not have the functioning acknowledgement and did not have the authorization to actually carry out monitoring visits in places of deprivation of liberty. That created a gap, lack of legitimacy for them, and that also made it very difficult for prisoners or detainees to lodge complaints and have their rights respected. To try to remedy to this inconsistency, the Subcommittee of the Prevention of Torture, which is the body created, the UN body created under the OPCAT, did a visit to Lebanon in 2022. However, after the visit, the government of Lebanon chose not to make publish the report, and that really is a problem because people from the civil society, but also officials, they could not remedy to the issues detected by the SPT, by the Subcommittee on the Prevention of Torture, because they will not be able to see what those issues are from the perspective of the UN SPT. Usually, this responsibility is actually filled by CSOs, civil society organizations, such as, for example, the Restart Center. They are the ones who monitor places of detention. They are the ones who provide minimal services to detainees, usually food, healthcare, sometimes psychological help as well. So there is an issue here that the civil society have to step in place of the government. And this is something that we see also in other contexts. But yeah, this is something that I wanted to flag here. The third issue, it will be quick. It relates to the lack of state services for torture victims. Unfortunately, in Lebanon and also in other places or other countries that we work with, we see that the states, they do not feel their duty to actually take care of the torture victims. They have an obligation to do so according to the Convention Against Torture, especially in General Comment number 3, the experts from the Committee Against Torture, they explain to what extent the state had the obligation to provide redress, to provide reparations, compensation to torture victims. However, it's not adequately done in Lebanon, and as for the treatment of detainees, CSOs usually have to take over and to provide themselves the services that prisoners need. That is still a problem because actually a lot of people, a lot of victims, they need more than the immediate care. They need more than the financial compensation. They need to be restored as individuals. They need to find their dignity. And they need to have legitimacy with the states to do so. They need public recognition and public acknowledgement. So that is still something that we would really recommend the state to work on, and that is still something that we are willing to collaborate with the authorities on.